This includes members' tablet devices, and they can connect to the Assembly Wi-Fi. We also are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under any consideration. Any member who has an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Agenda item 1, apologies. I have just one apology from Emma Rogan, and I just want to check who we have. No members who are joining us on Starleaf, and we have Doug and Gemma and Rachel and the Deputy Chair attending in person. In relation to Standing Order 1156, Emma has delegated her vote to the Deputy Chair. Agenda item 2, the draft minutes of the meeting held on the 7th and 10th of March. You'll find those at pages 5 to 8 of today's meeting pack, and if we are content that these are a true reflection of the proceedings of the meeting held on the 7th of March. Content? And members, you'll see the minutes for the 10th of March are at pages 9 to 21. Are we content that they're a true reflection of the proceedings? Content? Thank you. Brings us to item agenda 3, matters arising. It really is just one issue, which is to note that the informal meeting that was held with Family Mediation NI. The informal meeting was held with the Chief Executive of Family Mediation NI on Friday at last, the 11th. I attended along with Robin Newton, and staff produced a note of the discussion which can be found at pages 23 to 30 of today's meeting pack. The discussion centred around the significant and lasting impact on children and young people of poorly managed family breakdown when parents separate. Benefits of family mediation services in these situations, which was acknowledged by the Gillen Review of Family Law. The need to increase the provisions of such services, including consideration of the provision of funding and the funding model, the lack of collaborative approach by the Department with Family Mediation NI in relation to the Private Family Law Early Resolution Action Plan, and also the lack of progress with delivering the action plan. There were a number of potential actions which the Chief Executive of Family Mediation asked the committee to consider taking forward, and it's just to seek the agreement of members to write to the Department on the issues raised and to the Northern Ireland Commissioner for Children and Young People to draw to attention the matter and then what action can be taken to provide a copy of the letters to the Chief Executive of the Family Mediation for information. Read. And also just to remind members that this issue will be highlighted, we'll be coming to it shortly in the Legacy Report as one of the next Justice Committee's issues that they may wish to consider. Item 2, the Department of Justice response regarding the availability of the revised domestic abuse guidance. You'll find that at pages 31 to 33. At our meeting on the 10th of March, the committee agreed to request further information on the process for making the revised domestic abuse offence guidance available, how widely it would be circulated. The Department has indicated that the revised guidance has been republished on the Department's website, and that a link to this is included in the e-learning package targeted at frontline professionals who may come into contact with the victim of domestic abuse during the course of their work and in the public-facing awareness tool. Guidance can also be found on the landing page for the public awareness campaign on NI Direct. It has been shared with the multi-agency stakeholder assurance group for wider dissemination. Potential avenues for sharing on social media are also being considered, and it's just to note the position regarding the dissemination of the domestic abuse offensive guidance. Thank you. Item 3 is the Department of Justice response regarding a domestic violence court. You'll find that at pages 34 to 37. At our meeting on the 10th of March, the committee considered an update on delivery of the Year 6 Action Plan for Stopping Domestic and Sexual Violence and Abuse 7-year strategy, and agreed to request further information on the issues causing delay in the introduction of the Domestic Violence Court and the operational partners involved. The Department has responded outlining that the operational partners are in the NI Courts and Tribunal Service, PSNI, the Public Prosecution Service and the Office of the Lady Chief Justice. There are a number of decisions to be made and processes to be put in place before the introduction of the Domestic Violence Listing Court pilot, and work related to this is ongoing, including discussions with the judiciary. And is to ask members to note the position regarding the Domestic Violence Listing Court pilot unless they wish to submit any views or comments. And obviously this will be something again that I'm sure any new Justice Committee will want to keep an eye on, given the length of time it's taken to try and get even this pilot up and running, because this has been around for some considerable period of time. Rachel?
Chair, the only thing I appreciate all the information and the response. It's just, is this something that that they're going to be looking to commence this year? Is it because it's part of the 7-year domestic abuse strategy? So in year 6, so is this something that may happen before the end of the strategy? And just obviously there's been a number of delays for a long time, as you've said. So is, can we push forward with this? Is that something that they're hoping to do?
Okay, and just want to check, is this included in the legacy report as well?
No, I don't think it is. But we could put a reference.
Yes. Yeah, okay, thank you. Item 4, the Department of Justice response on the engagement with the Northern Ireland office in Brussels. You'll find that on pages 34 to 41. And again, on our meeting on the 10th of March, the committee considered an update on the EU exit and justice-related issues and agreed to request information on how the department engages with the NI office in Brussels and uses its work to assist with Horizon scanning for upcoming justice issues. The department has responded setting out details of ministerial engagement, events held in Brussels and officials' contact with colleagues in Brussels that have taken place, and that's for members to note. Item 5, the Department of Justice response dated the 16th of March, the Feminist Recovery Plan, and that is found at pages 42 to 44. Again, at our meeting on the 10th of March, we referred a copy of the Women's Policy Group Feminist Recovery Plan recommendations for the Department of Justice, which had been provided by the Committee for the Economy to the Department of Justice for comment. The Department has responded, indicating that the plan has previously been shared with the Minister, who met members of the Women's Policy Group to discuss the plan and recommendations last year. At the same time, the Department for Communities was developing a cross-departmental gender equality strategy, and many of the recommendations in the Feminist Recovery Plan were reflected in the expert panel report commissioned to inform the strategy. That work is continuing, and again, it's for members to note unless there's any other views or comments. Item 6, the Department of Justice response on the proposal for statutory rules as a consequence of the Registration of Clubs Amendment Act Northern Ireland 2021. Pages 45 to 47 set out the various papers. Again, at our meeting on the 10th, we agreed that that the committee was content with the proposals for 4 statutory rules required as a consequence of the Licensing and Registration for Clubs Amendment Act Northern Ireland 2021, and requested further clarification on how local producers affected by the timescale for the commencing of Section 11 of the 21 Act were being advised of the position. The Department has indicated that communication with local producers regarding commencement Section 11 is a matter for the Department of Communities. So, surprise that we got that. Again, it's for members to note. Item 7 is the Department of Justice response regarding the funding for the strategy for supporting women and girls in contact with the justice system. You find that at pages 48 to 50 of today's meeting pack. Again, at our meeting on the 10th of March, we considered the final version of the strategy supporting change, strategy for women and girls in or at risk of contact with the justice system, and related information, and agreed to request information on what resource bids have been submitted or budget allocated for the implementation of the strategy. The Department has advised that the action plan for the strategy is currently being developed, following which bids for actions emerging from it will be submitted in line with the normal financial arrangements. You'll be aware also that the Minister is launching the strategy at an event in the Long Gallery at 10 AM tomorrow, and we are invited to attend. And it's just to ask members to note the position regarding the funding, unless there's any other issue that we wish to raise, and also to note the event that's taking place, hosted by the Minister, tomorrow in the Long Gallery. Thank you. Item agenda 4 is the SR in relation to the Proceeds of Crime Act, application of the Police and Criminal Evidence Northern Ireland Order 1989, Amendment Order Northern Ireland 2022. Find that at pages 52 to 74. The statute rule is made under the powers conferred by 355 3A and 4593 and 7A of the Proceeds of Crime Act 2020, 2002, and will amend the Proceeds of Crime Act 2002, application of the Police and Criminal Evidence Northern Ireland Order 89 and the Northern Ireland 2016 Order to correct 6 minor drafting errors which are technical and do not impact on the policy or alter the use of the statutory powers, and will ensure consistency with the 1989 order in respect of the Northern Ireland PACE regime as it applies to the Proceeds of Crime Act. The rule also adds a new schedule to set out how Articles 17, 18, 23 and 24 of the 89 order should be applied to warrants and search and seizure powers under the Proceeds of Crime Act investigations. The committee agreed at our meeting on the 17th of June 2021 that it was content with the initial proposal for the statute rule to make 4 minor amendments and add a new schedule, and subsequently agreed at our meeting on the 16th of December 2021 that we were content for 2 further technical amendments to be included. The statute rule is subject to the negative resolution procedure. The Examiner of Statute Rules, in her report dated the 18th of March 2022, has noted that the order contains a schedule which purports to set out, for ease of reference, how certain provisions of the modified 89 order are to be applied. In the Examiner's view, the purported restatement of provisions of existing legislation may give rise to a risk of a lack of clarity and certainty. Furthermore, she notes that the schedule has not been given effect in the 2022 order. In response to the concerns of the Examiner, the Department has advised that it will amend the 2022 order at its earliest opportunity to remove the schedule, and the Examiner is satisfied with the Department's assurance on the approach in this particular instance. It is to ask members to note that they are content with the statutory rule, and if we are content with the statutory rule, I'll put the question. The Committee for Justice has considered SR 2022/74, Proceeds of Crime Act 2002, application of the Police and Criminal Evidence Northern Ireland Order 1989, Amendment Order Northern Ireland 2022, and has no objection to the rule. Agreed?
Agreed.
Okay, just to advise members that we'll now take the next 2 items together. That's an SL1 in relation to the County Courts Financial Limited Order and the County Courts Amendment Rules Northern Ireland 2022 Small Claims. You'll find this information on pages 3 to 30 of the table pack for the relevant papers. The papers were also emailed to members yesterday in advance of the table pack being issued. The Department of Justice is proposing to make 2 statutory rules which will be subject to the negative resolution procedure relating to an increase to the limit for small claims jurisdiction and corresponding reference within the County Court rules. The proposed rules will increase the jurisdiction of the County Court from the current level of £3,000 to £5,000 and make corresponding amendments to references in the County Court rules to reflect this increase. The proposal followed the outcome of a public consultation on the increasing the general jurisdiction of the county courts in Northern Ireland. The increase to the jurisdiction of the county courts is being made under the powers conferred by Article 22 of the County Courts Order, which are exercisable after consultation with the Lady Chief Justice. The committee previously considered the 2 proposals for the statute rules and agreed to defer further consideration until the formal consultation with the Lady Chief Justice was complete. The Department has now provided the Lady Chief Justice a response to the following. the formal consultation, and this can be found at page 8 of the table pack. The Lady Chief Justice has indicated the implementation will need to be carefully managed and that additional judicial resources may be required to provide greater flexibility to meet the business needs as they emerge. To accommodate this, she has requested that the increase should not come into operation before the autumn, and the Ministers agreed to postpone the operational date for the order until the 3rd of October 2022. The Lady Chief Justice also states that concerns regarding equality of arms remain for judicial colleagues. The Department has explained that costs cannot be claimed by litigants in the small claims courts, meaning claimants may represent themselves while larger companies or insurance firms may increasingly instruct legal representatives in the higher value small claims. However, the Department believes that the potential for this to happen is minimal, given that certain cases are excluded from the small claims court, and that it has also pointed out that a losing party in the small claims court is not exposed to the same risk of paying the winning party's costs as they would be in the county court. The Minister is minded to make the order to increase to the small claims jurisdiction of the county court from £3,000 to £5,000 this mandate, along with the corresponding changes to the references in the county court rules, and is seeking the committee's views on the proposals. I suppose it's for us to determine if we wish to note the information in light of the views of the Lady Chief Justice, and advise the Department of Justice that the next committee should give more detailed consideration to these proposals, particularly as they are not going to become operational until October 2022, or whether we are content with both the proposal to increase the small claims jurisdiction of the county court in Northern Ireland from £3,000 to £5,000 and the corresponding changes to the references in the county court rules in view of the additional information provided by the Department of Justice. All I'll say on that is I think it should be for the next Justice Committee to determine, given that there has been, now, the Department could still go ahead and do this. However, I think it would not be maybe good practice, and I think it would be only right that a new Justice Committee, given there's been an agreement that this would be deferred until October, then a new committee could, because they wouldn't have all the background that we have on this issue, and I think I'm trying to be fair to everybody in this. Agreed?
Yeah, I think that's particularly useful given the fact that we're not under massive time pressure. There isn't something which has to be in June, for instance, on it. So
No.
it does seem sensible just to...
And I don't think the Minister has fully adequately responded to the Lady Chief.
And I think that's another valid point. Yep. Okay, agreed?
Right.
Thank you. Item 7 is the licensing reform court fees, and you'll find that at page 78 to 96 of the pack. And at our meeting on the 24th of February, the committee agreed that it was content with two proposals for statutory rules, which will prescribe fees for new licensing applications which can be brought to the county court and the magistrates' courts as a consequence of the Licensing and Registration of Clubs Amendment Act 2021. The proposals covered applications to specify any part of the premises as suitable for the sale of alcohol, extension applications, repealing of all fees associated with the children's certificate, and the authorisation of underage functions with conditions met. The rules are not subject to any assembly procedure, and the Department will not be able to comply with the 21-day rule due to the timescale associated with the Department for Communities plans for the implementation of the second phase of the licensing reforms on the 1st of April. Due to a technical drafting issue arising as a result of two commencement dates being required by the Department for Communities on the implementation of the licensing reforms in phase 2, the required licensing fees amendments will need to be progressed by making 4 statutory rules and not 2, as previously advised to the committee. There is no change to the fee, the charging policy previously chaired, only the legislative process for implementing it. The Northern Ireland Courts and Tribunal Service therefore intends to progress its 2 statutory rules in March of this year, and another 2 will follow in April of this year. Fees expected to be introduced at each stage in each statutory rule are set out in the correspondence from the Department, which can be found at pages 78 and 79 of today's pack. and is to ask members to note the changes outlined to the legislative process for these fees unless there's any other comment. Agreed? That brings us then, members, to the agenda item 8, which is the draft committee for the Justice Legacy Report in 2017 to 2022. You'll find this at pages 98 to 141 of the pack for the committee's legacy report, and pages 33 to 34 of the table pack for a list of abbreviations to be included in the report. We are asked to submit, members were asked to submit any proposed amendments to the report by 4:30 yesterday to enable these to be circulated in the advance of today's meeting. There were no proposed amendments to the report that were received. Any typographical or formatting errors in the report will be amended at proofing stage of the report, and the figures highlighted in the appendices section of the report will be finalised after today's meeting. Just to ask members if they have any proposed amendments to the draft legacy report. If there's none. Yes.
Sorry, could I just propose the amendment to cover what was discussed earlier about the domestic violence?
Oh yes, okay.
Report? And just paragraph 82 of the report refers to the new domestic and sexual abuse strategy. And what I would suggest is that we expand that paragraph to also include monitoring of the delivery of the final year action plan for the current 7-year strategy to tackle domestic and sexual abuse strategy, and in particular progress to deliver the domestic violence court pilot.
Okay. Agreed with those amendments? Agreed.
Yeah, Chair,
Sinead?
we would have a number of amendments as well. Apologies for missing the deadline yesterday, so I don't know whether it's worth me rhyming them off here now or whether you want me just to circulate them to Christine or...
As many of them?
There's about maybe 5.
Oh, go ahead. Sure,
Okay.
I'll share them with them.
Yeah, just want me to go ahead?
Yeah, yes, go ahead. Yeah.
So we would like a specific reference to be made to legislating for raising the minimum age of criminal responsibility and for repealing the defence of reasonable chastisement. And we think this could be done either under their own headings or by specifying these two issues under the Youth Justice heading in paragraph 77. As well, specific reference to be made to capital projects relating to the upgrading of prison sites, new prison facilities under paragraph 84. A new heading to be added in relation to the ongoing assessment and review of progress towards a wider implementation of problem-solving justice initiatives. A new heading to be added in relation to considering the research commissioned by DOJ, which aims to identify the reasons why children from a Catholic background are disproportionately more likely to be detained in custody compared to other religious backgrounds. And that's it, Chair.
Okay. Obviously, you'll not be surprised that we won't be supporting paragraph 77 in terms of the issues will be raised. Those issues are actually included in the report. But obviously our position still remains in terms of raising the age of minimal consent and also reasonable chastisement. So, Christian, do you want to advise as to how these are only references? They're not proposals. They're only issues that were raised or discussed with it. How best do you want to deal with these?
I think the best thing to do is, Sinead, if you want to specify, do you want them included in the issues considered by the committee, or is it for the next committee?
For the next committee.
Sorry?
For the next committee.
For the next committee. If you want to then, perhaps if we work through and you just highlight where you want to put them in, do you want them under certain headings or brand new headings?
Well, I said there, I mean, the first one in terms of raising the minimum age of criminal responsibility and the defence of reasonable chastisement, you could give them new headings, but we'd be content for them to be under the Youth Justice head in paragraph, in paragraph 77.
Okay, the paragraph 77 reads Youth Justice Considerations Strategic Framework and the development of the Joint Secure Care and Justice Campus. So if members were content, I mean, what basically you're saying is consideration to be given to these, so we could add in consideration of the Strategic Framework for Youth Justice in Northern Ireland 2022-27 and associated action plan, including issues such as reasonable chastisement and the age of criminal responsibility. And then it would go on to read, and how the department is addressing the concerns of the Northern Ireland Commissioners' children. They raise slightly different concerns. So if members were content with that reference, it's basically saying consideration to be given to them. The other potential place could be under the Justice Miscellaneous Provisions Bill, but we don't know what the department's bringing in that, so I'm not sure. That's why we didn't specify anything under that, because we're not sure what it's going to cover. It's probably the Youth Justice reference would be better.
The base of what Rachel said in the House the other day, it'll probably have about 500 schedules and 47 clauses, and
Yeah.
you know, there's a whole raft of things in the kitchen sink. Everything's going to be thrown into that miscellaneous provisions bill. We're content in the sense of it's an issue that has been raised numerous times, but our position still remains that we would not be, we will not be in favour of those things. So as long as that's reflected, we're content that that's included.
So the paragraph would read then, consideration of the strategic framework for youth justice in Northern Ireland 2022 to 27, an associated action plan, including issues such as reasonable chastisement and the age of criminal consent, and then it would carry on the way it was.
Yep.
Okay. Do you want to deal with the next one, which is paragraph 84, major capital works in relation to prisons? What was that? Just go over that again, Sinead.
A specific reference to be made to capital projects relating to the upgrading of prison sites and new prison facilities under paragraph 84.
Which is in favour of the upgrading of, okay. Great. Then the third one,
A new heading to be added in relation to the ongoing assessment and review of progress towards wider implementation of problem-solving justice initiative.
okay. And then number 4 is about Catholic children in relation to the justice system. What was
So,
that?
A new heading to be added in relation to the research which was commissioned by DOJ, which aims to identify the reasons why children from a Catholic background are disproportionately more likely to be detained in custody compared to other religious backgrounds.
Do you want that under a new heading, or would that fit under the youth justice?
Probably, well, a new heading. If you think it would go into youth justice, I'd be happy enough.
Okay.
We'll do it under new heading.
Good, thank you, Chair.
Okay. In terms of, so there was amendments that Christian raised at the beginning. There's these amendments. So, great.
Great.
Okay, members, then we'll, with that done, we will then go to the report. Just give me 1 wee minute to make sure. So the format and formal, so we'll go through the report, so bear with me until we get through this, please. Format and formal agreement of the report, which is the title pages, table of contents, list of abbreviations, acronyms, remit, powers and committee membership. And I put the question, are members content that the title page, table of contents page, list of abbreviations, acronyms, remit, powers, committee membership page stand part of the report? Agreed?
Agreed.
Review of 2017-22 mandate scrutiny. Then we have, that refers to paragraphs 1 to 63. And I put the question, are members content that the review of the 2017-2022 mandate scrutiny section of paragraphs 1 to 63 stand part of the report? Agreed? Review of the 2017-22 mandate approach. You'll find that at paragraph 64 to 73. I'll put the question, are members content that the review of the 2017-22 mandate approach adopted by the committee section at paragraph 64 to 73 stand part of the report? Agreed? Then we have the review of the 2017-2022 mandate issues the incoming committee may wish to consider, and you'll find that at paragraph 71 to 93.
Subject to the amendments.
Subject to the amendments. And we'll put the members are content that the review of the 2017-2022 mandate, subject to the amendments, issues the incoming committee may wish to prioritise sections paragraph 71 to 93 stand part of the report. Agreed? Appendices, the appendices 1, 2 and 3 of the report, and they provide details of the committee membership, facts and figures, committee's expended during the mandate. Appendices 2 and 3 can only be finalised following today's committee meeting, so I put the question, are members content that appendices 1, 2 and 3 stand part of the report, and also seek the agreement of members for the report to be published on the committee's webpage? Agreed? Thank you for that, for your help through that. That brings us to agenda item 9, the implementation of the new stalking offence. And you'll find that at pages 143 and 149 of today's pack. The 24th of February, the committee noted that the new stalking offences will come on into operation when the Protection from Stalking Bill receives royal assent, and agreed to request information on the current position regarding the provision of the guidance and the new offence and the rollout of the training of the PSNI and the Public Prosecution Service. The Department has advised that the guidance on the implementation of the new stalking offences is currently being refined and nearing final completion. As it is still a work in progress, the Department cannot share it with the committee at this stage, but will ensure that it is ready for publication, laying in the Assembly upon the bill receiving royal assent. With regards to the training, the Department has stated that the PSNI and the Public Prosecution Service are developing training modules and internal guidance taking into account the draft guidance. However, it may be the case that not all criminal justice partners will be able to be trained before the stalking offences take effect. The PSNI has also confirmed that there are some challenges in respect of the wider training of frontline officers and staff members, as they have not yet received the finalised statutory guidance, which remains the key element of any training package of this nature. A significant range of work has, however, been undertaken in preparation of the new legislation, and this is outlined in its response to the committee. So it's for the members to note the current position regarding the statutory guidance and the training for the new stalking offence, unless there's any other comment. The only thing I'd have to say, members, is the letter from the PSNI was worded very cautiously. I think they could have been more brutal. To say that there remain some challenges in respect of the wider training is probably putting it mildly, and I think it is an issue of concern that in a haste to put these things in place, and none of us are opposed to the legislation that we've endeavoured over this particular mandate and previous times here to have enacted, but I do think that it is only right that the right guidance is in place, the right training is in place. And how many times has members of this committee not raised that particular issue, and still we find ourselves in a position where we have the commencement order should not have been whenever the commencement order was, and that would have given everybody the time. However, I think there still is, if you look at these correspondence, there still is a willingness and a commitment, but I think it masks the pressure that all those organisations are under in terms of being fit for purpose to ensure that this legislation is ready to be enacted in a way that is to the benefit of those that it was intended to serve. So it's just for members to be made aware of that. Thank you. Item 10, the strategic framework for youth justice. Hope that wasn't a fraudulent slip. Strategic framework for youth justice in Northern Ireland. You'll find that, members, at pages 151 to 277. Again, at our meeting on the 10th of March, we considered the strategic framework for youth justice for 2022 to 2027, the related 5-year action plan, and they agreed to request further information on a range of issues, including how the Department intends to address the concerns of the Northern Ireland Commissioner for Children and Young People and the children's organisations going forward. The Department has responded, providing further information request, and has confirmed that it is committed to continuing its engagement with children's sector and listening to their concerns as consideration is given to implementing the strategic framework and the action plan. An initial meeting with the sector representatives is planned in early May, which will be the starting point of the process. And again, ask members to note the additional information unless there's any other comment. And also to seek the agreement of members to forward a copy of the response to the Children's Commissioner and the Children's Organisations who provided a response to the committee for information, and advise them that this, together with the development of the Joint Secure Care Justice Campus, are issues that have been highlighted in the Legacy Report as ones that the next Justice Committee wish to prioritise. Agreed? Agenda item 11 is the Northern Ireland Prison Service Independent Monitoring Board response to issues that were raised, and you'll find that at pages 279 to 287. The Chair and Vice Chair of the Northern Ireland Prison Service Independent Monitoring Board Executive Council attended our meeting on the 24th of February to discuss the role of the IMB in general and specifically in relation to the care and supervision units. During the oral evidence session, the IMB representatives raised a number of issues regarding the operation of the IMBs and the support provided to them, including the recruitment and training of members, and the committee agreed to request a response from the department. The department has now provided the information on the framework for the operation of the IMBs and the general duties of the role, the reporting mechanisms for the IMB to raise issues, the secretariat support provided to the board, the training provided to members, the recruitment, the remuneration of members, the department's response to the last 3 IMB annual reports, and the department has also indicated that while it has not issued a formal response to the IMB annual reports, it will consider issuing a response to these to further reports, and highlighted that the IMB also had a positive meeting with the Minister on the 16th of March. And the department has also set out the current position of the provision of body scanners in prisons as outlined by the Director of Prisons when he attended our meeting on the 3rd of March, and it's for members to note. And also, could we agree to provide a copy of the correspondence to the Chair of the IMB Executive Council for their information? Agreed? Agenda item 12 is the Civil Justice Modernisation Delivery Plan Progress Report. You'll find that at pages 289 to 315. In our meeting on the 24th of February, the committee noted the consultation to be undertaken by the department on the merits of extending registered intermediary support to the civil and family courts, which was one of the priority areas in the Civil Justice Modernisation Delivery Plan. Given the slippage on the particular consultation, which was to be delivered between July and September of 21, the committee agreed to request an update on the delivery of the rest of the priority areas in the plan. The department has now provided an update on the progress in each of the priority areas, and has stated that while there has been slippage in anticipated delivery timescales in some areas, much has been achieved in a relatively short period of time, and the slippage where it has occurred has generally been as a result of the pandemic-related resource pressures, including the resource of external delivery partners, or has been due to consideration of issues emerging through stakeholder engagement. Again, it's to ask members to note the update on the delivery of the priority areas in the Civil Justice Modernisation Delivery Plan. Read. Correspondence, item 13. There are 7 items of correspondence at pages 317 to 348 at the meeting pack, and 6 items at 361 and 36 and 81 of the table pack. And I'll draw your attention to 5 of the items in the table pack. Members will then have the opportunity, if there's any other comments that they want to make in relation to the correspondence. Item 13.11 at pages 40 to 64 of the table pack is correspondence from the Department of Justice advising that it laid the Government Actuary report of his review on the determination of the personal injury rate in Northern Ireland in the Assembly yesterday, and it has provided a copy of the report. The rate determined by the Government Actuary is 1.5% and comes into effect today. The Department has advised that the discount rate remains low as a result of high expected inflation in the short to medium term, low expected interest rates in the longer term, and the anticipated return on bonds and equities remaining low. The next planned review of the rate will commence on in July 2024. Item 13.12 is pages 65 to 72. and its response to the Minister of Justice and the President of the Victims Payment Board regarding the Troubles Permanent Disablement Payment Scheme and the challenge of accessing medical information in a timely manner. The Minister has outlined that while securing medical information remains a challenging aspect of the scheme, work is being undertaken by officials in the Department of Justice, the administrative team supporting the Victims Payments Board, Capita, Department of Health and the Health and Social Care Board to ensure that the information can be accessed in a timely way and to maintain a focus on the scheme being victim-centred. The President of the Victims Payment Board has set out the work currently being undertaken to address the challenges of accessing the medical information in a timely manner, has outlined the interim arrangements that has been established. He has also indicated that the Board's administration scheme is committed to processing applications as quickly as possible and is pleased to report that in recent weeks there has been a positive increase in the number of cases submitted to Capita for assessment, as well as an increase in the number of completed assessment reports being returned. And it's for members to note the correspondence from the Minister and also from the President of the Victims Payments Board, and also I think it would be right in keeping with our commitment to those organisations which had raised this issue over a period of time, that a copy of the responses is provided to the representatives of the victims group for their information. Right. Item 13, 14 at pages 73 to 76 of the table pack is a copy of the summary report of the Committee for the Executive Office Stakeholder Event in relation to the Violence Against Women and Girls strategy. The report highlights that attendees believe that the engagement by the Executive Office has been poor, but they cited that the approach adopted by the PSNI in relation to its Violence Against Women strategy is an example of good practice. And again, just ask members to note. Item 13.15 is correspondence from Committee for Education, providing a copy of an update from the Department of Education on the pilot Operation Encompass scheme in Northern Ireland. Feedback to date on the pilot scheme has been very positive, with a total of 51 referrals received by schools from the police. The Department of Education will be leading the rollout of the Operation Encompass once the regulations are in place, and a working group comprising key stakeholders is being convened to develop and implement a phased rollout by the start of the next academic year. And again, is to note the position in regards to the Operation Encompass scheme and the rollout of this across Northern Ireland. And again, are members content to action the items of correspondence as set out both in the cover sheets, or is there any other comments we wish to raise? Content? I just think there is one issue that I noticed in the correspondence, and I think it was from the department in relation to pay review for the prison staff, and I noticed that they have made a decision. If I can just get the correspondence, they have made or imposed a decision in relation to the pay situation. Now, my understanding of that is that it hasn't been done in conjunction with the pay and review body, and that does raise some concerns as to why this has been done in this manner. And I don't think there's much that we can do. Yes, it's in the correspondence that we got from the progress to deliver the recommendations of the review of the support services and operational prison staff and retired staff. And the last paragraph reads, "We have shared the indicative results arising from the grading review with the Prison Officers Association, and this has formed the basis of the pay negotiation for 2021. The POA is currently balloting members on the terms of the pay offer." And I think that does raise concerns as to why the pay and review body wasn't involved, because if I remember right, the agreement to enact the pay and review body was on the basis of that the prison service wouldn't enter into strike action. And I would worry that there would be now a view, and it will undoubtedly be something that I'm sure will be raised over the next few days, that if the agreement has been breached by no referral of the pay award to the pay and review body, that then there may be no longer the commitment by the Prison Officers Association to stay true to the agreement in regards to industrial action. So it is a concern, it is a worry. I don't say that to encourage that to be the case, but I think it would only be right that it was raised as an issue, and it will undoubtedly be something that the next Justice Committee will have to deal with. Okay, members, thank you. You'll be glad to know, no chairman's business. And then that brings us to any other business. Just to advise members that this is the last scheduled meeting of the committee in this mandate, and to seek the agreement of members for me to approve the minutes of today's meeting, and also to seek the agreement of members to the committee staff issuing a standard letter in response to any correspondence which arrives after today's meeting and before dissolution starting, and the committee has no further meetings, but the correspondence has been forwarded to its members. Agreed. Also, we've been instructed to remind members to return our Surface Pros, chargers, stylo pens to the IS office. Mine has disappeared. And can I then just, on a personal basis, conclude by saying that I want to thank members for their contribution. I want to wish Emma Rogan, Robin Newton and Sinead Bradley all the best. They are not standing for re-election, and I want to thank them for the work that they have done. I want to thank Sinead Bradley particularly, who was always a very willing participant in all that has gone on in the committee, and also my colleague Robin, and wish them well in their future. But I also want to say this to you as members of the committee. I came to this committee with no real intense view on all the issues that this committee has had to deal with. It was a baptism of fire, but I want to thank you for your patience. I want to thank you for your help. We have worked through a huge amount of work. I think if you look at the legacy report, I think particularly in relation to legislation, this committee has made a very, very invaluable contribution to shaping, moulding and improving legislation that has gone through the House. So to you all individually and collectively as committee members, thank you for that. I also want to thank Christine and her staff who are with us all today. A sincere word of thanks. No one knows, other than ourselves, a huge amount of work. Like I read out there reference to pages 4 to 7 and in the table pack and in all of that. That takes a huge amount of work, and that has not gone without note, and I could not have done my job as chair of this committee without their invaluable support. And I want to personally and on your behalf to say to them, thank you. I'd like to thank Carita for always ensuring that there was biscuits on the table, although I do note that we've got scones today. But thank you. It's been a pleasure to work with you, and I want to wish you well as members. Whatever the electorate decides, whoever is back, whatever that's an issue for them, but I wish you well, and I have no doubt the paths will cross at some stage over the next number of weeks and months. But thank you very much.
Thank you, Chair.
Chair, sorry, just before can I just say, our thanks to you as well. I think you've been a very gracious chair. I think you've been very diligent in the way you've approached the vast workload as you've outlined there in terms of what this committee has had to do. So I just want to recognise your effort and your commitment since you've come on board around the same time as myself, and echo your comments in terms of the thanks to the staff, and to wish everybody else around the table well.
Thank you. Thank you very much. Thank you, members.
30.